Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Okay, let's unpack this. Imagine you're an innovator. You've got a brilliant idea, but, well, it's so versatile it could technically be 2 or 3 separate inventions. How do you protect all of them under patent law? That's precisely what was at the heart of a fascinating case recently decided by the Madras High Court. Today, we're taking a deep dive into this crucial judgment. It's a case that has significantly clarified a really important aspect of patent law in India concerning something called divisional applications. Our mission is basically to walk you through the whole story, from the basic facts to the court's reasoning and, what it all means for IP moving forward.
And what's really interesting here, I think, is how just a few words in the law, in the statute, can cause so many problems with interpretation, and how the court really tried to cut through that ambiguity to set a clearer path for inventors, but also, importantly, reinforcing the responsibilities of the patent examiners themselves.
Definitely. So let's set the scene, lay out the basic details for everyone. The case is CMA PT number 45 of 2024. It was heard in the High Court of Judicature at Madras, and the judgment we're looking at was delivered by the Honorable Mr. Justice Senthil Kumar Ramamurthy. That was on March 4th, 2025.
Okay, and the parties involved.
Right. The appellant, the one bringing the appeal, was University College London UCL, represented by their constituted attorney, Govardhan Gajal, and the respondents were the Indian patent authorities. So, the Assistant Controller of Patents and Designs from New Delhi, and also the Controller General of Patents, Designs and Trademarks from Mumbai.
Got it. And who was arguing the case for them?
For UCL, the appellant, it was Senior Counsel Mr. P.V. Balasubramaniam, working with Mrs. Anshul Sarastri and Ms. Preetha Natarajan. And for the respondents, the controllers, it was Mr. K. Subbaranga Parathi, who was the central government standing counsel.
Okay, so we have the players. What about the timeline? How did this all unfold?
Well, the story actually starts way back. The priority date for the invention itself was claimed in 2006.
2006, wow. Long history.
Yeah. Then, sometime before 2008, UCL filed its first application, the parent application. That was No. 5924-CHENP 2008. It was for a colonic drug delivery formulation. And importantly, it specifically mentioned coatings using polysaccharides like amylopectin and starch.
Amylopectin and starch, okay.
Then later, in 2014, they filed this divisional application we're talking about now. 8266-CHAMP 2014. This was for a delayed release drug formulation. The idea was that their original application actually covered more than one invention. Specifically, it included other types of polysaccharides for coatings, too.
Ah, so they were trying to carve out protection for those other polysaccharides separately.
Exactly. But then, fast forward to May 24 and 2024, the assistant controller rejected this divisional application, and the core reason given was based on how they read Section 16(1) of the Patents Act. The controller believed, essentially, that they had to raise an objection first, saying, hey, you have multiple inventions here before UCL could file a divisional.
Right, that seems to be the crux of the procedural issue.
It was. So UCL appealed that rejection pretty quickly, which brings us to this Madras High Court judgment on March 4th, 2025. And here's where it gets really interesting. At the heart of it all were these 2 patent applications from UCL, both for drug formulations, but crucially, with different chemical makeups.
Okay, so the parent patent.
The parent patent, which did eventually get granted, actually patent number 531129, granted March 30, 2024, that one focused on coatings made from amylopectin and starch.
Right, the ones mentioned initially.
Yes, but the divisional application, the one that got rejected, was seeking protection for coatings using a completely different set of polysaccharides. We're talking about chiosin, chondroitin sulfate, cyclodextrin, dextrin, and carrageenan.
Okay, a whole different group.
Exactly. So the central question became, were these 2 groups of chemicals genuinely separate inventions? Or was the second group just, a variation or an offshoot of the first?
Which leads us to UCL's arguments before the High Court. What were they saying to challenge that rejection? Well, their main point, and it's a big one, was about Section 16(1) of the Act. They focused on the phrase, if he so desires. UCL argued really strongly that this wording gives the applicant, the inventor, the unilateral right to file a divisional application.
Unilateral meaning they can just decide to do it themselves.
Yes, exactly. At any time before the parent patent is granted. And crucially, even if the controller hasn't raised any objection about the original application containing multiple inventions, what's called a lack of unity of invention.
So they're saying, we don't need your permission or prompting. We can decide to split this ourselves.
Precisely. They argued the controller had simply misinterpreted this fundamental right given by the statute. They also tackled the substance of the invention. They argued the claims of the divisional application were clearly different in scope from the parent patent.
Because of the different chemicals.
All right, parent patent, amylopectin and starch. Divisional application, chitosan, chondroitin sulfate, etc. Totally different lists. Because they were different, UCL asserted, granting the divisional wouldn't result in double patenting, getting two patents for effectively the same thing.
That makes sense. What about evergreening? Was that a concern?
They addressed that head on too. Evergreening is that practice where companies try to extend a patent's life by filing for minor tweaks. UCL pointed back to that original priority date, 2006, as evidence. They were saying, look, this isn't some new tweak we came up with later to extend the patent term. This concept dates back to the original filing.
Okay, so defending against potential criticisms there. Anything else?
Yes, a really important point on data. UCL claimed they had provided enough material, detailed experimental results, graphs, the works showing the unique performance, the gastro-resistant effect, of these other polysaccharides in the divisional application. And they argued that the controller's rejection order was flawed because it didn't give any real reasons why this submitted data failed to establish a plurality of invention, why it didn't show these were distinct inventions.
So basically, we gave you the proof, and you didn't even explain why you thought it wasn't good enough.
That's the essence of it, yes. A lack of reasoned justification in the rejection.
So UCL laid out a pretty comprehensive case. How did the controller side, the respondents, react to all this? This part's quite interesting.
It really is, because surprisingly, the Central Government Standing Council represented the controllers, largely. Well, they conceded on the main legal point about Section 16.1.
They conceded. You mean they agreed with UCL?
Pretty much. They submitted, and this is almost a direct quote, that the controller did not duly appreciate the language of subsection of Section 16 regarding that unilateral right to file.
Wow. Unexpected.
It is. And following that admission, their suggestion wasn't to fight it, but rather that the matter may be remanded for reconsideration.
Sent back downstairs, basically.
Exactly.
Yeah.
Sent back so the controller could properly examine the substantive question. Does the divisional application genuinely qualify as a distinct invention based on the original disclosure? It was less a counter-argument and more an acknowledgement of a mistake in interpreting the law and a suggestion for how to fix it.
So given UCL's strong arguments and this surprising concession from the respondents, what did the Madras High Court have to decide? What were the key legal questions left?
Right. The court had a few critical things to sort out. First, the fundamental interpretation of Section 16.1. Does it really grant that unilateral right to file without a prior objection? That was number one. Second, would granting this divisional application actually lead to problems like double patenting or evergreening? And third, perhaps most crucially for the remand, did the data UCL provided sufficiently establish that there was indeed a plurality of invention, that these other polysaccharides represented genuinely distinct inventive concepts?
All right, so how did the court rule? What was the final decision?
Well, the court's decision has some pretty significant implications. First off, they decisively set aside the assistant controller's rejection order from May 2024.
Okay, so UCL won that part.
Yes, and they remanded the whole matter back for reconsideration, just as the Respondents' Council had suggested might be appropriate. But the reasoning is key. The court explicitly clarified Section 16.1. They ruled that the phrase, if he so desires, does grant a patent applicant the unilateral right to file a divisional application any time before the parent patent is granted.
So confirming UCL's interpretation.
Exactly. And explicitly stating this right exists even in the absence of an objection from the controller about lack of unity. This directly overturned the assistant controller's initial interpretation.
That's a major clarification then. Does that mean inventors can just file divisionals whenever they want for whatever reason?
Good question. And no, the court put a crucial boundary on that. They were very clear. While the applicant has the right to file the application unilaterally, that application is only sustainable, meaning it can only proceed if the claims in the parent application's complete specification genuinely do relate to more than one invention.
I see. So you can file it, but it still has to meet the substantive requirement of having multiple inventions disclosed in the first place.
Precisely. The controller still has the duty, upon receiving such a divisional application, to examine whether that parent specification truly supported multiple inventions. The right to file doesn't automatically mean the divisional patent will be granted.
Okay, that makes sense. It balances the applicant's right with the integrity of the patent system.
Exactly. And the court also pointed out that major flaw in the original rejection order. Remember the data UCL submitted.
Yeah, the experimental results for the other polysaccharides?
Right. The court highlighted that the controller's order mentioned this data, but completely failed to provide adequate reasons as to why that data didn't establish a plurality of invention. That lack of reasoned analysis was a key justification for sending it back.
So the controller can't just say no, they have to say no because...
Essentially, yes. They need to explain their reasoning, especially when evidence is presented. And for the remand, the court set specific terms. To ensure fairness, maybe avoid any subconscious bias, they ordered that the reconsideration must be done by an officer other than the one who issued the first rejection.
A fresh pair of eyes.
Exactly. And they set a deadline.
Okay.
A reasoned order must be issued within 4 months after giving UCL a fair chance to present its case again. And importantly, the High Court made it clear they weren't ruling on the merits of whether UCL's divisional should be granted, just that the original rejection process was flawed and needed redoing properly.
Okay, so the core issue, whether those other polysaccharides are a distinct invention, is still technically open, but the process for deciding it has been clarified. Did the court refer to any other cases, any precedents?
The main focus was really interpreting Section 16(1) of the Patents Act itself. That was central. They did note, interestingly, that the controller's original rejection order had mentioned a decision from the IPAB, the old Intellectual Property Appellate Board.
Which one was that?
It was a case called ESCO Corporation v. Controller of Patents and Designs from 2020. In that case, the IP had actually found there was a plurality of invention and said a divisional should be allowed.
So the controller mentioned a case that kind of went against their own decision.
It seems that way. Now, the High Court didn't explicitly say they were relying on ESCO for their own ruling here, but mentioning it suggests it was definitely part of the relevant legal background that the controller should perhaps have considered more carefully, especially when they re-examine the case.
Got it. So stepping back, looking at the bigger picture, what's the real impact of this judgment? What's its precedential value?
I think it's quite significant, actually. First, it gives a really definitive interpretation of Section 16(1), that unilateral right to file is now much clearer. It makes the process potentially more applicant-friendly, procedurally speaking.
But with that caveat we discussed, it still needs to be a legitimate split.
Absolutely. Second, by sending it back because of poor reasoning, the High Court put a strong emphasis on accountability and examination. Patent authorities need to provide detailed, reasoned decisions. It raises the bar for transparency.
That seems crucial for trust in the system.
It really is. Third, that order for a different officer to handle the reconsideration. That's a key procedural safeguard. It reinforces fairness and the idea of an unbiased review, guarding against predetermination.
Makes sense.
And finally, the judgment itself has neutral citation. Yes, marked on it. That signals the court's intention for this ruling to be easily found and cited. It's meant to serve as a strong precedent, binding or at least highly persuasive, for future cases dealing with divisional applications in India.
So wrapping this up, what does this all mean? What are the key takeaways from this deep dive into the University College London appeal?
Well, I think the key takeaways are pretty clear. For patent applicants, you now have a more clearly defined unilateral right to file divisional applications before the parent grant. You're more in the driver's seat procedurally. However, the burden is still very much on you to prove that your original application genuinely disclosed more than one distinct invention. That substantive requirement hasn't changed.
And for the patent authorities?
For them, it's a strong reminder, maybe even a directive, that their decisions need to be transparent and well-reasoned. They can't just reject applications, especially divisionals filed under this unilateral right, without clearly explaining why, particularly when evidence has been submitted.
Yeah, this judgment really underscores how vital that precise legal interpretation is, doesn't it? Especially in an area like IP that's meant to encourage innovation. So for you, the listener, if you're an inventor or involved in intellectual property, what does this ruling make you think about? How might it change your strategy for protecting inventions that might have distinct but related aspects? Does this clarified right offer a useful safety net for ideas that evolve after the initial filing, or does it maybe encourage inventors to be even more precise and comprehensive right from the very beginning? Something to consider.